Does this work yet? Do these not work till they turn everything on? Are y'all back there for crowd control or to support something? Okay, a good answer.
Good to know.
Senator, you can go ahead and sit at the table if you'd like. Well, we got two and one. We're gonna go. Yeah, we're gonna go by first come first serve in the door if that's okay. But we'll go ahead and start. Unless y'all want to switch it out, you feel free to discuss amongst yourselves. We'll start in 1 minute. Okay. What a gentleman. All right. Good afternoon. We will go ahead and start. Before we do, I would first like to thank the public safety professionals in the room and throughout our state who keep us safe and allow us to conduct the people's business in a civil manner. We appreciate you, and we appreciate your colleagues not here. With that, we'll ask Representative if you'd start us in a prayer. You're 23.
Let us pray. Dear Lord, be with us today as we hear these bills that will affect us and the lives of those in Georgia. Keep us, lead us, guide us in your will. Amen.
Thank you, Representative New. Senator Kirkpatrick, you are here to present Senate Bill 155. Is that correct?
That's correct.
All right.
The LC that I have is 3891S.
3891S, and that is a substitute for the legislation, and that is what we have. Thank you. If you'd like to start presenting.
Okay, thank you very much. Some of you have already heard this presentation, but I'd like to thank my friends in the back of the room for coming to put an exclamation point on why we're doing this bill. Georgia has a long history of protecting public service animals dating back to 1983. This section of law was amended in 2015 with the passage of Tanya's Law, arising out of the death of canine Tanya in Walker County, shot and killed in the line of duty. We're naming this bill, and this is one of the reasons for the substitute, FIGO's Law, in honor of a canine shot and killed in Sandy Springs in October of 22. Since 2015, canine officers are being used for an increasing number of tasks. Most recently, electronic detection of cell phones in correctional institutions and other electronic surveillance tasks, over and above the traditional search and rescue functions. The intent of Tanya's Law was good, but by creating 4 different levels of harm, there's been confusion between 2 of the sections by judges and juries. So this bill does 3 things. First, it simplifies the definition of public safety animal and search and rescue animals to incorporate all of the new functions that have come up, and that's why you'll see a lot of lines struck through on page 2. Number 2, it simplifies the offenses to 3 different levels to eliminate the ambiguity in the current law. And these are, first, interfering with a public safety or search and rescue animal, which is a misdemeanor. And we did change the language in there by removing the word taunting, which is more commonly used for people. And we also have the second category, which is harming an animal, which is a high and aggravated misdemeanor. And then the third level is aggravated harming of the animal, which is a felony punishable by 2 to 10 years of imprisonment. But this can be reduced with an agreement between the prosecution and the defense, and that should be in your sub. The bill also requires restitution, including vet bills, retraining, or replacement. Our canine animals cost the dogs about $20,000 due to their specialized training, and horses even more than that. I've been working with the Prosecuting Attorney's Council on this bill, and this bill should make the law protecting these important team members simpler and easier to administer in the court system. I'm happy to answer questions, and I believe there are some prosecutors in the room as well in case we have lawyer questions.
Thank you, Senator. When I was a sheriff's deputy, my unit was with the canine, where the canine unit was, and it's very clear the special bond the handler has with their canine. So we appreciate that, and as well as what you stated in terms of a law enforcement asset and the expenses that go into it. Do we have any questions from members of the committee? Going once, going twice. We do have testimony. 155. Okay. Claudine Wilkies, if you'd like to come to the podium or to the table if the author prefers.
I just signed up only if you needed questions answered, that's all.
Okay, thank you. If you want to stay there in case something comes up. Mr. Rock or Miss Rock? Sorry, I couldn't see the first name, so I wasn't sure.
I have that lawyer handwriting that's kind of travel. Jessica Rock, Prosecuting Attorney's Council, Animal Crimes Prosecutor for the state. Just here if you have any questions. We have worked very closely with Senator Kirkpatrick on this bill and believe that it's made a lot of improvements that were needed.
Thank you. Maisie Lynn. Thank you. I'm just bad at reading handwriting.
Doesn't look like it sounds either. And I'm joined by Emily Strongwater.
Sure.
Ms. Strongwater is a defense attorney, handles a lot of federal cases here at the Northern District, and is a member of our organization. I'm Maisie Lynn Gerton, the Executive Director of the Georgia Association of Criminal Defense Lawyers, We do have a few remaining concerns about this legislation, and I guess I feel like I need to talk about my bona fides here. I'm the child of a law enforcement officer. He was 31 years with the Virginia Beach Police Force before he retired, and about 40 years ago was a canine handler himself. So have fond family nostalgia about the relationships and the bonds, and fully appreciate the worth and value of these animals, and yet still have some concerns about the letter of the law and how it would be applied to people as they interact with them. I would just start by turning your attention to line 59 of the bill. There's going to be two other places where this happens in the bill, lines 59, 75, and 88. The language reads, intentionally commits, conspires, or attempts to commit an act that, and then goes on to talk about the acts. I know you all handle a lot of criminal legislation in this committee, and so are probably well aware that in Title 16 and Chapter 4, we already have codified the mechanisms by which the prosecution can charge someone with attempting a crime or conspiring to commit a crime. And it would be our position that by including that here in this part of the code section could be potentially confusing, but certainly you have those mechanisms already in place and don't need to have them here in this individual law. Our suggestion would simply be to remove conspires or attempts to commit, so that you're just intentionally committing the act. Then that way, if it is an attempt or if it is a conspiracy, the prosecutor then pulls in 16.4.1, 16.4.8 to reflect that reality. That occurs at lines 59, 75, and 88. We do appreciate certainly removing the taunting language from line what is now 60, but are still concerned about I always get this word wrong, but anthropomorphism that is maintained in that line, believing that you've captured the idea of what happens when an animal is frightened, agitated, or harassed in the fact that you have hindered the animal in the performance of its duty there in line 61. We just feel like it would be a more surgical approach to dealing with the actual problem of hindering the performance of these animals versus trying to deal with these concepts of feeling that we typically don't attribute to animals. Finally, the concern that we've raised, two more things. One that we've raised every time we come before you when there's a mandatory minimum sentence like there is in this bill, now found at lines 94 through 98. We'd certainly appreciate the senator's adjustment, adding the escape valve that we see in some other parts of the code. Unfortunately, this type of escape valve is only at the discretion of the prosecutor. It reads as if the court has some say in it, and the court does have some say in it, but only after the prosecutor has had their say. I will tell you that there's not a defendant who would be unwilling to have their sentence reduced, but certainly there will be prosecutors who will not, though there will be some who will. But ultimately, ought it be the sentencing body, the judge's discretion? We believe that it should be, and would commend that to you as well. Another thing that I'm sure you all come up against quite often is the concept of restitution. It is currently available in our law that someone convicted of a crime can be held accountable to make right through restitution any of the damages caused by that crime. It's akin to what would happen in a civil case. We might think of that as damages, but without having to go through a lawsuit. This is available today, right now. I will tell you that to the extent that the money is a motive in passing this policy, I think it's a troublesome one, given that over 80% of the people that are prosecuted in our courts are indigent. So even when restitution is assessed, it's rarely collected in those public defense cases. I just want to raise that to your attention when we're talking about policy on the basis of recompense for loss, like has been mentioned by this bill. One other thing that I have to admit I just noticed, and I'm mostly just curious about if anyone's up for answering it, is why the forensic pathology services have been removed from this part of the code. Just seems to me that there might be good reason to want to still have that information, even though you're changing the sentencing on this law. I just was surprised and hadn't seen that last week when we were preparing for the full committee hearing. But if you have any other questions, I'd be happy to answer them, and Ms. Strongwater might have some practice tips that she could provide if you had specific questions about cases.
Thank you, and I'll remind the audience, if you'd like to testify, you can come up, but just kidding. Would y'all like to answer anything about the forensic pathology or anything brought up forward before we go to commit?
Thank you, Mr. Chair. The last one's simple, and that is simply that the GBI does not perform necropsies on animals. So that's why that's in there. I think the other ones are a policy difference, and we specifically tried to, in the line 1661, we separated A and B because it's possible that people can frighten, agitate, harass, or tamper with an animal who's off duty, who's in the police kennel or the police stable in a number of different ways. And that is why that is separated from line B, which actually refers to the animal and the performance of its duty. I'm trying to find the others. And again, the question came up when I presented this bill before about intentionally is in the bill in all three sections. So there has to be an intent to do all of those different levels. Harassment is certainly defined in multiple other code sections that have to do with everything from texting and while driving and things like that. Let's see, what else was there? And then the part about commit, conspire, attempt, that was sort of shoot and miss type of a language. And the restitution, I can't comment on whether someone actually ever pays that or not, but I think that it should be in the bill just because of the extremely high cost of dealing with these animals. And my prosecutors may have something to add to my non-legal explanation because, as you know, I'm a doctor and not a lawyer.
All right, thank you. Rep. Jackson, did you have?
Thank you, Mr. Chair. I had a question too about restitution. I see the fines are spelled out for misdemeanor on line 80, and the fines are spelled out for felony on line 94. How do you determine restitution, or who determines restitution?
The sentencing judge. But a fine is separate and apart from restitution.
Right.
We're trying to match that would be in this legislation, for instance, at line 94, if a person was convicted and sentenced to that, they could be fined up to $50,000. That $50,000, if it were fully assessed, is not going to go to the local law enforcement agency that lost their service animal. Fines are all distributed in that manner. Restitution would be, and restitution is determined at a hearing. Both parties, the state and the person that's being prosecuted, would have a chance to present evidence, and we might have some more details on how that plays out. If you'd like some.
Most of my practice is in federal court, where sort of an independent third party makes those calculations, and then both sides get to sort of present evidence as to what they think the loss is. But a fine is separate and above in addition to whatever restitution would be.
To the restitution, okay. Thank you.
Could I ask Mark?
And we want to match what the federal government is doing as well when it comes to that. And as a former prosecutor, we know that the judge will take into considerations the defendant's situation. And there's plenty of cases I've worked on where the restitution was actual medical damages, and there was a finite number, $300,000, for example, that we knew the defendant would never be able to pay.
Right.
But those are taken into consideration through the judge.
We having no any further testimony, having no further testimony or comments from committee. What is the pleasure of the committee? Do we have another? Oh, one moment. I think we have one more. I apologize. I misread the bill number you're coming for. I'm going to let you mention your name.
Everybody, I'm Keith Camerod. I obviously work for State Patrol. I was K9 Figo's handler from the very beginning, from when I had him. They asked me if I'd come up and speak. I just support the act that the senator's putting over, the bill that the senator's putting up to increase the penalties and what goes against the people that intentionally do harm to the service animals. They're willing to go out and do whatever we ask them to do without a second hesitation or without even thinking twice about it. So if somebody's willing to intentionally cause harm or attempt to cause harm to an animal that has no idea why it's doing it, what it's doing, other than it's being asked to do it, I'd support that, there be a stronger punishment pushed against them to cover the damages and the charges that they're doing to the animal that's being put up forth for work.
Appreciate your testimony. I think you brought someone who would have direct knowledge on the bill. Does he want to testify, he or she?
He's got a thing or two to say.
Well, we appreciate y'all and thank you for the testimony. What is the pleasure? Move to pass. Second. All in favor? By aye? Aye. Any opposed? The bill passes to full committee.
Thank you very much.
Thank you.
And I apologize for mispronouncing Figo's name. Thank you.
Thank you. All right, and without further ado, the superstar of the Senate, as he told me to say, Senator Roth. Senator Robertson, so it is a pleasure to see you. We have here Senate Bill 159, is that correct?
That is correct, Mr. Chairman, and I don't think I could ever call myself anything other than a pain with a straight face.
Well, we'd never say that to your face. What LC number do you got?
The LC number I've gotten, and Mr. Chairman, I want to apologize. I've been working on this with with the Legislative Council today, and Jen and her hard work for the last 2 days. But what we're working off of right now is LC 393896 Sierra S. And thanks to the Department of Corrections and help from talking to individuals with the Georgia Sheriff's Association and others, I think we've cleared up any issues that we had in the previous bill. And I'd be happy to go over the entirety of the bill again, or if you just want me to address some of the changes, I think we've kind of cleared up a lot of the issues related to intent, because what we've done is where the bill changes that, we reference back to existing law that discusses how the actions are determined, where you see on line 51 and 52, where it says, except as otherwise provided in paragraph 4 of this subsection, any, and then we go with existing law, person who commits or attempts to commit a violation of subsection B of this code. And if you look at subsection B, where it states very clearly on line, I think it's 32, that says it shall be unlawful for any person to obtain for, procure for, or to give to an inmate a gun, pistol, or other weapon or intoxicating liquor. It goes back to existing law to try to clear up some of those concerns about intent, which I think were well founded with the original. But what we've done is we have stuck to making it a felony for an employee or other person to introduce contraband into our correctional institutions, with our primary focus on cell phones and things of that nature. And we have made the term of imprisonment 10 years, but we have allowed, this is something that the judges can probate, suspend, do as they feel fit. The primary purpose of this bill at the beginning is the Department of Corrections works really hard to keep those environments safe. And we need to send a strong message to the individuals that work in those institutions, the individuals that contract to do work there, and others, that there is zero tolerance for bringing these dangerous devices in there. And where we have cases out of that I mentioned the other day, where we had a gang that was making millions of dollars while incarcerated, setting up assassinations and having them carried out outside the prison walls, all with the use of a cell phone, while posting a lot of their actions, videoing it and posting it on social media. And I'll tell you right now, the individuals that were standing in the back of the room, the colonel with GSP and my friend from Post, the representative, all of us in law enforcement look at corrections as absolutely the most dangerous place to work. Because we go in there and we don't have the tools that we have when we're on the street and other places, and the concentration of bad to good is extremely disproportionate. And I think this legislation, now that it has been cleaned up and straightened out, I think does exactly what we want it to do, and I'm willing to answer any questions, Mr. Chair.
Thank you, Mr. Whip. And we have one question from Rep. Neal.
Yes, thank you to the chair and to my friend in the hot seat. So I did review everything, and I think you addressed everything we discussed prior to, and being more specific when it comes to employees and contractors, and everything else is pre-existing. And I do see some minimums going up, but I'm not completely against it as long as it's going up for the right people. As we talked about before. So with that, I would definitely support the bill now. So thank you.
Thank you.
Thank you for that. And we will go ahead and hear testimony on the bill. We have one signed up. We Ms. Gurdon and Ms. Strongwater, the dynamic duo. Never mind then.
Very quick. We have not had a chance to talk about the sub with Senator Robertson, despite knowing that he's been very busy on it. We touched base yesterday, but are really grateful for the modifications to the bill, removing the strict liability provisions that were in the first version and lining it up with all that you've intended to do here. Just really appreciate you hearing our feedback and with the bill you've come up with. Never excited about enhancing penalties, don't get me wrong, but understand that this is a policy decision that you all need to make, and appreciate that. Just appreciate that you've heard some of the responses that we've had on the bill.
I greatly appreciate that, and I hope this is being videoed. Because she and I usually don't have these kumbaya moments, but I appreciate her support through this process. She is a friend.
Thank you.
And Senator Robertson, I know even tempered praise is appreciated by you. With that, there is no other comments and no other testimony. What is the pleasure of the subcommittee? All right, I had two motions do pass. I'll take one as a second. All in favor, say aye. Aye. All opposed, the bill passes to full committee.
Thank you, Mr. Chairman. Thank you.
And
Committee
thank you. We are adjourned.
members.